My name's Barry Wood. I'm the Assessment Division Director for the DLGF, and welcome you to the first webinar of the year, certainly not the last. And the title or the content of this webinar came from suggestions that we had received from people wanting to know, hey, what is the role of the assessor? Maybe they are the current elected assessor and they were like, what do I do? Maybe they're a deputy and considering running for an assessor. Maybe it's just a taxpayer or an other individual who's interested in the role of the assessor. So we'll try and address all the subjects, all the things that the assessor does. If you do have any suggestions for future webinars, although we pretty much have 2024 pretty well planned out, if you do have any suggestions, please let me know or Jenny know in terms of what you would like to see presented in a future webinar. So before we get going, I do have to give this disclaimer that this is an informative presentation only and does not take the place of Indiana law. The Indiana Code always governs. So frequently, if you contact me, I will probably give you either an Indiana Code citation or an administrative code citation, our rulemaking authority, or I may also ask you or tell you or recommend or suggest that you contact your county attorney for specific legal advice, because many times the situation is fact or case specific and your county attorney can provide you with legal advice or guidance. So today we're going to talk about the role of the assessor, dealing with other offices, resources, and questions. So as far as the role of the assessor, start off with the assessor is the only non-constitutional office in the courthouse. So you have, say, like the auditor or the treasurer, prosecutors, things like that. But the assessor is a non-constitutional office, meaning the county assessor, township assessor is not limited in terms of the number of terms that they can serve, unlimited, whereas, say, like the auditor is restricted to 2 elected 4-year terms or 8 years in a row. So one of the questions I receive every now and then is, it seems like it's a taxpayer saying, I want to talk to the assessor's boss. And who is the assessor's boss? And sometimes they think it's the DLGF because we're the oversight agency, but the actual boss of the assessor, be it the county assessor or the township assessor, are the voters in that jurisdiction. So if the taxpayer wanted to contact the boss of the county assessor, they'd have to contact all the voters in the county. So the Indiana Code states that the county assessor shall be elected by the voters. And if the county assessor ceases to be a resident of that county for whatever reason, then they would forfeit the office. And the term of the assessor is for 4 years, beginning January 1st and continuing until a successor is elected. So the last election for the assessors was in 2022. So the next one will be 2 years from now, 2026. In order to be a candidate for the county assessor position, we'll talk about the township assessor in a little bit. But anyway, a county assessor must have resided in the county for at least 1 year before the election, and the candidate must own real property located in the county upon taking office. And unfortunately, the Indiana Code does not specify how big that property must be. One of the comments has been, could they own a piece of land or property the size of a postage stamp? And the answer would be yes, although that would be a very difficult legal description to find out, but there's no minimum or maximum real property requirements in terms of owning the property, but they must own the property. A question came up this morning in the webinar in regard to an assessor and what happens if the assessor satisfies the requirement for living in the county a year before the election and they own the property upon taking office, but sometime during the course of that 4-year term, they sell their property. And what happens then? Does that person, are they disqualified? Or what if there's a time lapse between when they own own the property and when they sold it and when they buy new property. That would be a local control issue. But I suspect if somebody were to own property, say you own a house and you're planning on moving to another house, you probably would have a pretty good idea as far as what what property you're going to purchase. But unfortunately, the Indiana code does not address that situation per se. It just states the candidate must own real property located in the county upon taking office. In order to run for office, or actually to take office, an individual must have, if they've never held the office of county assessor, they must have at least their level 2 certification through our office before taking office. So conceivably, a person who has never held the office of county assessor decides to run, and prior to the general election in November, they did not get their level 2. Could they take office by January 1st? As long as they could get their level 2 in that 6 to 8 week time frame prior to the election, it would be possible. We would certainly recommend that if a person was considering running for county assessor, that they get their level 2 before putting their name on the ballot, but it is not a requirement. The only requirement is that the individual attain their level 2 and have it when they take office on January 1st. If an individual has held the office of county assessor either currently or say 8 years ago and decided to get back into the arena, the assessment arena, they must have attained a level 3 assessor's appraiser certification through our office upon taking office. And so a question this morning was, in essence, how long does a person have to get, what time frame is involved in terms of getting their level 3 designation? So if I were elected as county assessor in 2022 and I had my level 2 by January 1st, 2023, when I took office, I, in essence, would have 4 years to get my level 3. And the reason I say 4 years is because I would have met that criteria for holding the office of county assessor, and I would have to have my level 3 certification upon taking office in, say, January 1st, 2027. So basically, level 2 if you've never held the office, level 3 if you've held the office are the requirements for the certification. One question that also comes up, especially around election time, is who polices this? Who governs or who stipulates that, hey, this person does or does not have their level 2 or their level 3? And there's a couple of different things. One is on our website, we do have a list. We keep it as current as possible. The most recent list was January 3rd, but we have a list statewide of all those individuals who have their level 2, level 1, level 2, and or level 3. But in terms of the challenge to a person's residency or owning property, or whether or not they have their level 2 or level 3, that would be handled at the local level. Our office would not be involved in that. So if somebody wanted to challenge someone's eligibility or qualifications, they would have to do it at the local level and not through our office. Mentioned that if the elected assessor ceases to be a resident of the county and that they forfeit the office, and talked about the 4-year term until, you can see, begins January 1st after the election, and it continues until a successor is elected and qualified. The assessor shall keep an office in a building provided at the county seat by the county executive being the county commissioners. Most of the time, the office is going to be either in or near the courthouse, but there could be say an extension office or something, another office in close proximity, but it should be in the county seat. And you can see that the office hours are to be specified regular business hours, and it's specified on days by the county executive. In 2008, the legislature did give the opportunity or the option for the county assessor to establish satellite offices in the county. I do know there are a couple counties that do have more than one office, but that's totally optional, not a requirement. In terms of what are the actual duties of the assessor, the first one you can see in the Indiana Code citation there is countywide equalization. In other words, making sure that the assessments are done on a fair and equitable basis throughout the county. The second duty is the selection and maintenance of a countywide computer system. One of the biggest duties or responsibilities for the assessor is certification of the gross assessed values to the county auditor by July 1st each year. Another duty or responsibility is the discovery of omitted property, and that could be personal property if you're aware of a business personal property filer who is either not filed a return or maybe did not include all the property. The assessor can go after the omitted property, or there may be some situations with real property where something may not have been picked up, say like a pole barn or a shed or something like that. So the assessor has the opportunity to discover omitted property. In 2008, there was a legislation, we'll talk about it here in a second, in which the assessing duties of the township assessor were transferred to the county assessor. And basically, in the township, in that situation, it's the township assessor's duties were assumed to be done by the county assessor unless the township assessor, excuse me, in the referenda process for retaining the duties was retained by the township assessor. So in essence, in 2008, we had 1,008 township assessors, trustee assessors, and after the election process in 2008, that number was decreased to 13 township assessors statewide. And if you were to look at a map of the state of Indiana, all 13 township assessors are located on or in a line north of I-70 going east to west or west to east, Interstate 70. So say from Wayne County over to Vigo County in any place north. So the north half of the state is where the township assessors are located, the 13 remaining township assessors. If there has been a transfer of duties between the assessors, it does not affect any assessment or any appeal or any pending legal action that the prior township assessor or trustee assessor assumed. If the individual elected to the office of township assessor now, and switch gears a little bit, has not attained their level required, be it a level 2, we'll talk about this in a minute, level 2 for those that had never held the office, or level 3 that for those that had held the office of township assessor previously. Those duties are then transferred or sent over to the county assessor. And once that township assessor attains their certification, say they're level 2 or level 3 certification, then the assessing duties would transfer back to the new township assessor from the county assessor. One of the other primary duties or responsibilities of the county assessor is that they serve as the secretary to the Property Tax Assessment Board of Appeals, the PTABOA. They are a non-voting member, regardless if you have a 3 or a 5-member board. The county assessor is a non-voting member, and I've heard rumors that maybe a county assessor is is a voting member of their PTABOA, and that is not the case. The county assessor is a non-voting member of their PTABOA. It does not prevent county assessor from serving on the PWA of a nearby county, a next door county or another county. They could do that, but they cannot serve as a voting member on their own PWA. As you can see, they shall keep full and accurate minutes of the proceedings of the board. So if you're an elected county assessor, please make sure that you do not serve as a voting member on your PWA. For those counties that do have a township assessor, the Indiana Code states that the county assessor shall, not a may provision, but they shall have at least one meeting of the township assessors and advising them of various aspects of their duties and also trying to ensure uniformity in assessment procedures. In some situations, maybe the township assessor and the county assessor's office are located right next to each other in the courthouse, but at a bare minimum, the county assessor shall have at least one meeting with the township assessor. It doesn't specify when that meeting is. Perhaps it is in this time frame, early January, just starting off the new year, but could be held in July for all I know. So at least one meeting should be held or shall be held between the county assessor and the township assessor. So I mentioned township assessors and the change back in 2008 in terms of when the legislature passed legislation to, in essence, do away with the trustee assessor position, township trustee assessor position, and then also the township assessor position. You can see some of the population and parcel count requirements in terms of which townships would have been eligible for retaining their duties. And as I mentioned, back in 2008, there were 43 township assessors that were eligible for this election to have their duties retained, and of those 43, 13 township assessors still remain. Talking about this subsection or this part of the code talks about what I've just discussed basically. Much like the county assessor, the township assessor's term is for 4 years, and much like the county assessor, if the elected township assessor ceases to be a resident of the township, then the assessor forfeits that office. So if a person moves, outside of their township, their jurisdiction, even if it's just across the township line, if they're no longer a resident of that township, then they would forfeit their office. Much like I mentioned the 4-year term, its term begins January 1st after the election and continuing until a successor is elected and qualified. Like the county assessor, the same premise holds true for the township assessor, and that they have, if they've never held the office of township assessor, they have to have their level 2 upon taking office. And if they've held the office of township assessor, even if it may have been 4, 8, 10, 12 years, however long ago, they would have to have their level 3 assessor certification by the time they took office on January 1st. In terms of other statutory duties, and this goes back to the change in 2008, basically the township assessor would assume that their duties would be assumed by the county assessor unless the township assessor had been voted, the voters in their township elected to have the assessment duties continue on with the township assessor instead of the county assessor. And I mentioned there are 13 current township assessors and mentioned that they're in the northern half of the state. And of those 13, 5 of the township assessors are in Lake County. So who's responsible, what happens in terms of placing an assessed value on a parcel or property. And basically, as you can see, the code citation there is after or starting July 1st of 2017, an employee or the elected township assessor of a township assessor who is responsible for placing an assessed value must have obtained the level 3 certification. So in other words, if I'm an employee in a township assessor's office and I'm responsible for placing the assessment of a property, real property, and defending that in an appeal process or working with the taxpayer, and must have attained my level 3. If I'm simply an employee in the township assessor's office and I do data entry, or I'm responsible for personal property, or I just go out and I help do the data collection, taking the tape measure out or taking pictures, I don't necessarily have to have my level 3. Although certainly we would recommend every employee, if possible, get their level 3, because that would demonstrate their education and training and knowledge, and that would help taxpayers know that their assessment is being done as accurately as possible. But at a bare minimum, a person who is responsible for placing an assessed value should have their level 3. So what happens if the township assessor has not attained their level 3? We talked about the duties, upon taking office, but also you can see this code citation does allow for the appointment of a deputy or employee to, in essence, handle the work for that person, and or if a township assessor contracts out with a firm or someone, that individual should have the level 3 as well. You may not know this, but there are some criminal penalties and infractions that could be levied against an assessor, and either an elected assessor or an employee of the assessor's office. And you can see first is a person who knowingly and intentionally falsifies the value of a transferred real property, or omits or falsifies any information required to be provided in the sales disclosure form, commits a level 5 felony, not a misdemeanor, a level 5 felony. So pretty serious charge if that is proven. Also, a public official, could be an elected official or an employee, who knowingly and intentionally accepts a sales disclosure that falsifies the value of the property, or omits or falsifies any other information in regard to the sales disclosure form, they commit a Class A infraction. So I'm not an attorney, but my understanding is a Class A infraction obviously is not as severe as a level 5 felony. In terms of this legislation that was changed back in 2022, effective for January 1st, 2023, an officer of state or local government, so it could be the DLGF, a state government, who recklessly violates or fails to perform a duty imposed upon him or her under, you can see those various code citations, and that's all part of Indiana Code 6-1.1 is all part of the property tax assessment process. But if they, as you can see, if they recklessly violate or fail to perform a duty under those code citations, they commit a Class A misdemeanor. And in addition, the officer, not the office, but the officer or the individual is liable for damages sustained by a person as a result of their violation. So there could be monetary damages sustained and paid to the person who is aggrieved by the action or inaction of the official. So an assessing official or representative of the DLGF, so we're not excluded from this at all, is that knowingly assesses any property at more or less than what the official representative believes is the proper assessed value, or fails to perform any of their duties and recklessly violates any of the other general assessment provisions of this article commits a Class A misdemeanor. I have not heard of this happening or anyone being charged by their local prosecutor in regard to this, but as soon as I say it, I'm sure somebody's out there going to say, well, yeah, this happened to our county on XYZ date, or there's always a potential that it could occur. So please, for the assessing officials, be it the elected assessing official or their deputy and their employee or representative of the DLGF, please don't do anything that would get you in hot water, so to speak. Or as I was used to be a township assessor, and as my predecessor said, don't do anything you can't explain on the front page of the paper, or nowadays, I guess, in social media, but please be careful. Confidential information is another situation that occurs, we get questions on, there is some confidential information. Typically, we think of confidential information as being, say, like in the business personal property return, and that may include earnings or income information or other confidential information. That information is to be kept confidential, and if you're not sure if it should be confidential or not, there's a couple things you can do. One is, especially in regard to the business personal property returns, on our website and on all of our forms, we will state whether or not some information is confidential or not. So for example, business personal property return forms 103 long or 103 short and the 104 form. The 103 long and the 103 short forms, up in the upper right hand corner, it will specify, it will state that this is a confidential form or confidential information, and the information is to be kept confidential. Whereas the 104 form is more of a public form and it is not confidential. But having said that, there is some confidential information that may be disclosed to others, officials or employees of the state or the United States government. And for example, I mentioned I was a township assessor previously, and one of the things I remember, we were approached by the FBI. The FBI was investigating a taxpayer, and the FBI came to us and requested copies of the business personal property return for that taxpayer. So in that case, even though it was confidential, we could disclose that information to the FBI, or if it were a state police investigation, something like that. If you have a question on whether or not something is confidential, I would encourage you to reach out to your county attorney to get an opinion, or you could reach out to the Indiana Public Access Counselor. Luke Britt is a state public access counselor, and he could give you an official opinion on whether or not something is confidential, and or if it could be disclosed to another individual that is not within your office. I had a question early in this morning's webinar in regard to email, and are emails confidential? And the answer is it depends. And I hate to be wishy-washy about it, but the situation obviously depends on what is in the content or the nature or the subject of the email, and in terms of, is there any proprietary information or something that cannot be disclosed or needs to be redacted. So in that case, in terms of emails, you would, like I said, I would contact your county attorney for an opinion, or contact the state public access counselor's office to get a definitive opinion. That way you know for sure what you can or cannot divulge to others that is confidential in nature. This also includes information, if a county has a vendor that helps with their, helps with their real property assessments or does personal property audits, whatever the case may be, those would also be subject to the confidentiality of the information. There are a couple of exceptions to this. The first one being in regard to confidential farm property records, so agricultural farm property records. The first is for the Indiana State Board of Animal Health. If there was something, say there was some sort of virus or something where they had to look at the discovery of a disease or something, that the State Board of Animal Health could have access to, say, the Form 102 farmer's return. Also, the Department of Agricultural Statistics at Purdue, in terms of the what Purdue does to look at agricultural statistics. And then the last category, any other state agency that needs the information in order to perform its duties. That doesn't exclude, in the case of, you can see, if somebody has an appeal, obviously, some information must be disclosed in an appeal process. However, say like at a PWA hearing or an IBTR hearing, there could be a case where the information has to be disclosed in a private setting, or maybe the information is redacted. I mentioned that employees and also companies that may have a contract or employed with the county, those individuals are also subject to not disclosing confidential information. If it does happen in some situations, then the contract could be potentially terminated. So it just really depends on the situation and what happens. I mentioned, the farm and agricultural properties, but there also is information that could be confidential information that could be disclosed. And this is specifically for oil or gas interest. And typically we see the oil and gas interest in the southwestern part of the state. But if there's a situation where a property was going up for tax sale, and somebody wanted to potentially bid on the property that's eligible for the tax sale, they would want to know who owns the property, or are there any leases for that oil or gas interest. And so that information could be divulged in the tax sale process. And if you had any questions about that, certainly, like I said, I would suggest contacting your county attorney to get their official opinion on what information could be disclosed. But you can see that it could be lease information. It could be in terms of what is the interest being sold, and also the applicable percentage or allocation for that oil or gas interest. So, like I said, this is specific to oil and gas, and primarily going to be in the southwestern part of the state where we would find this. So confidential information is disclosed. Person that is denied the right to inspect or copy information could file a complaint with the public access counselor. So that's why I suggested maybe being proactive and contacting the public access counselor if you did have any specific questions, or you were not certain or sure whether or not that information could be disclosed. You may want to do that ahead of time, because you could potentially have a person saying, hey, I tried to get this information that is public information from my assessor. The assessor denied me the information, and the public access counselor could potentially rule against you and say you must divulge it. So is it better to be proactive or reactive? So if a person does disclose confidential information, be it an assessing official or an employee of the assessing official, they shall be immediately dismissed from that position. And also, this also holds true for a company or somebody that has a contract with the county. If that person did if a contract employee or company did divulge that information, you can see that that contract would be void as of the date of the disclosure, and they would benefit, or they would not be able to benefit, or they'd have to forfeit their rights to any payments, future payments under that. And then also they would be barred for 3 years from entering into another contract. So there would be a 3-year statute of limitations, so to speak, or a statute of prohibition from having a contract. Also, you can see number 4 there, it says the taxpayer whose information was disclosed has a right of action for triple the damages against the entity. So this could have a huge fiscal impact as well, depending on the situation. If there was unauthorized disclosure of confidential information, the official, be it the an individual or employee, they could be liable for liquidated damages in the amount of $500 or the actual damages resulting from the unauthorized disclosure. So just better safe than sorry. If you have a question or an issue about whether or not something is confidential, please get legal advice first or an opinion from the public access counselor. A lot of times people use the term or the word assessor and appraiser interchangeably, and certainly on our level 1, level 2, level 3 certification, we say assessor appraiser. In this situation, the used appraiser, it's being used in terms of an assessor appraiser, not to be confused with, say, an assessor who, or excuse me, an appraiser who is licensed under the professional licensing agency. They would be subject to the terms and conditions of being a professional appraiser under the public licensing agency instead of our agency. Tax representative, you can see means a person who represents another person at a proceeding between, before the PDBA or the IBTR, for example. A tax representative does not include the owner of the property. So if I am a homeowner and I file an appeal, I do not need to be a tax representative. If I am appointed to represent that owner, so maybe I appoint or have my sister or an uncle or somebody like that represent me. If a person is a full-time employee of the owner of the property, so maybe you have a company and the company filed an appeal, a person who's a full-time employee of that property owner does not need to be a tax representative, or a person representing a local unit of government appearing on behalf of that unit. They do not need to be a certified tax representative. A CPA, if they're filing an appeal or a matter that relates only to personal property, they do not need to be a tax representative. And then also finally, an attorney who is a member in good standing in the Indiana Bar or any other state bar who has been granted temporary admission to the Indiana Bar does not need to be a tax representative. Basically, an individual who is a township assessor or a county assessor or an employee or an appraiser shall adhere, not may, but shall adhere to uniform standards of professional appraisal practice. So for those of you that have your level 3 certification, you've taken and passed the USPAP class and you know what's entailed with the uniform standards of professional appraisal practice. So I won't go into that, but if you do, you agree or you are abiding by the USPAP criteria. An individual who's an assessor, assessing official, or employee shall not do any of the following, and that is conduct an assessment that includes reporting of a predetermined opinion or conclusion. So you can't go in and say, oh, I'm going to automatically make this person's assessed value $100,000 or $1 million. You can't have a predetermined amount. Misrepresent the role that you are providing, except you're assessing the property. Miscommunicating with the intent to mislead or defraud a person, or communicate a report that is misleading or fraudulent, or knowingly permit an employee to communicate a misleading or fraudulent report, engage in criminal conduct, or willfully or knowingly violate the requirements of the Indiana Code citation. Perform an assessment in a grossly negligent manner. And unfortunately, grossly negligent is not defined, but it would certainly have to rise to the level where you've done something pretty egregious to be deemed grossly negligent, or performing an assessment with bias. Obviously, it's hard to disclose or hard to discern what is bias, but somebody could potentially make the case that you went out and assess their property and you were against them from the get-go, so to speak. So it does not prevent the assessor or employee from certainly advocating for your assessment. Typically, this is going to be found in the appeal process and defending the assessment or the methodology used in the assessment. So you certainly have the right to do that, and you're expected to do that. A couple of years ago, the Indiana General Assembly passed legislation regarding complaints from taxpayers or individuals against assessors. And we, as a state oversight agency, we do have a standard operating procedure in place that if we do receive a written complaint from a taxpayer, it doesn't have to be in writing, it could be an email, for example. But if we do receive a written complaint in regard to an assessor, be it a township assessor, elected township assessor, elected county assessor, or an employee of the assessor's office, or an appraiser, that we could receive a complaint, and the complaints can be centered on the competency of the assessing official, and in terms of did that person do the work correctly or accurately? If the taxpayer or the person complaining believes that their assessment has not been done correctly, they, like I said, may submit a written complaint to our office. We then have 30 days to respond to that person's complaint. To date, we've already had 2 complaints filed against 2 separate county assessors. We investigated and reviewed the information and found that the county assessor had not done anything wrong, but we do have a track record already of, unfortunately, having 2 complaints having been filed with our office. One thing that we will not do is if the complaint, if a person submits a written complaint to our office, and that person has an appeal pending, be it at the local level, the PWO level, or at the state level, say with the IBTR or at the tax court, we will not investigate or act on that complaint so that we do not prejudice the appeal process. So the first question I typically ask if I receive an inquiry or a complaint from a taxpayer about an elected official or an employee of an official is I will ask if they have an appeal currently active, in which case if they do, then we have to sell them. We cannot act on that complaint until after the appeal process has been completed. If we did find something where an assessor had done something in terms of gross incompetence, then we could revoke that person's level 3 certification or level 2 certification. And if we did revoke that person's certification, the individual could appeal our decision to what's called the Certification Appeal Board. And fortunately, that Certification Appeal Board has not had, we've never had to meet. And the Certification Appeal Board, you probably have never heard of it, but it's comprised of 7 members, 2 representatives of the DLGF, 2 individuals appointed by the governor, and those must be either a township or a county assessor, 2 individuals that are licensed appraisers, and then the 7th person who is just a resident of Indiana. They don't have to be a property owner or anything like that. They just need to be a resident of the state. The commissioner of the DLGF designates the person from the DLGF, one of the 2 appointees from the DLGF, to serve as the chairperson, and no more than 4 members may be of the same political party. And each member, as you can see, serves at the pleasure of the appointing authority. If we did have to meet, you can see that each member would be entitled to per diem, salary per diem, and also reimbursement for expenses. If we did revoke somebody's level 2 or level 3 certification, it could not be for more than 3 years. And also, if somebody was served or was part of a company or a contract vendor, and we revoked their certification, then that contract that they had would be void. And again, they would not, like the other situation we mentioned, they would not be able to receive any additional payments under the contract. And contract entered specifies a contract entered into by the appraiser must contain a provision specifying that the contract is void. So if you're negotiating your contract with the reassessment vendor, you do have to have that provision in your contract. Going to switch gears now and talk about the assessor and dealing with other offices. And you can see there, on a regular basis, the township assessor or the county assessor, you're going to be dealing with other elected county officials such as the auditor, the treasurer, commissioners, county council members, county attorney, the DLGF, probably get sick and tired of hearing from me all the time. Legislative Services Agency, LSA, and LSA is a nonpartisan arm of the General Assembly. You probably would be hearing from or meeting with members of the General Assembly and or their staff, your state senator or your state representative in your area. To a lesser degree, depending on your situation, you may be involved or meeting with the Indiana Board of Tax Review. In some situations, you may be dealing with the county recorder or the surveyor. If your town or township or county have a building and planning or zoning department, towns or city councils, mayors, clerk treasurers, town managers, and then other elected officials, appointed officials. The one group that's not listed that I purposely did not list because it's almost taken for granted is you're dealing with taxpayers, be it on a township or a county level. You're dealing with taxpayers on a daily, hourly basis, it seems like. So that would be your primary individuals that you may be dealing with. In terms of resources, there are several resources that certainly as an assessing official that you could use in the conduct of your office and running your office. First is our website and Gateway. And our website, we have a lot of information, and also Gateway, part of our website has a lot of information, especially fiscal information, but also on Gateway, that's where the assessor will submit their annual PETA report. It was due this past last week, January 15th. So our website and Gateway has a lot of information. The Indiana Board of Tax Review has a lot of information. They publish their decisions, so you can go and find various case law in terms of different areas of assessment that have been decided by the IDTR. Same with the Indiana Tax Court, all their decisions are published. The Indiana General Assembly, certainly if you're interested in a legislation that's either currently being proposed or legislation that may have been passed in the past few sessions, that's certainly a good place to get information in terms of what was in the actual legislation that was passed. The Indiana County Assessors Association, we, the DLGF, work closely with the Assessors Association, especially with the two conferences, the January conference that was just last week, and then the upcoming summer conference in August. You may be wanting to reach out to the Association of Indiana Counties, the AIC. They have a lot of information. The IAAO, the International Association of Assessing Officers, has a ton of information. Brilliant, who is our contract provider for continuing education, they have several things you could consult with. And then finally, for manufactured mobile homes, the National Automobile Dealers Association, the NATA Guide, that would be another resource. So with that, Jenny, do we have any questions? And as Jenny gets ready to tell me what questions we have, here's my contact information. So if you do have any questions you think of after this webinar, please reach out to me and or to your field assessment division field representative. So Jenny, any questions?
Yes, we do have one, Barry. One of the questions, it goes back to when you were discussing about the complaints. Where does the complaint get addressed to?
So if a taxpayer wants to file a complaint, they could send the complaint, the written complaint, to me, or they could send it to or Commissioner Dan Shackle or Emily Chrysler, who's our general counsel. They would send it to the DLGF, and typically what happens with the complaint process is it will come to me first, and then I will review the complaint. I will reach out then, typically, like I said a minute ago, if we do receive a complaint, I'll reach out to the person that had filed the complaint to see if they do have an active appeal. And if there is no active appeal, then that would set in motion our reaction to the complaint, and we would do our due diligence, not only following up and getting more information from the person making the complaint, but also we would reach out and talk to the assessing official or the vendor or whomever the case may be to get their side of the story, because certainly there are two sides to every story, and we would try and do our due diligence to make sure we have all the information, the best information available, and then make a determination on whether or not any future action should be taken. So good question, but primarily the complaint process, written complaint process, starts with me, and or as I mentioned, a person could send a letter or an email to the commissioner or to our general counsel, and it will get handled, as soon as we receive it. So, other questions?
We don't have any other questions. I don't know if there were any from this morning that you wanted to bring up and share this afternoon. And if you do have any questions, you are welcome to go ahead and enter them into the chat box now. We'll try to get those addressed before we finish up. Barry? Yeah,
I think I was able to address the questions from earlier today. One is talking about the level 2 and level 3, and how long does it take? How long does a person have to get the level 3 if they had their level 2 and they're a new office holder? And then the same way, if you've held the office previously, do you have to have your level 2 or your level 3? Talked about the confidentiality for emails and reaching out to the public access counselor's office, and then also talked about owning property and what happens if a person moves, and again, that's going to be fact or case sensitive, specific. So certainly your county attorney, even if you're a township assessor or county assessor or an employee of the township or county, certainly your county attorney can provide you with legal advice and guidance, because that's part of what they're paid for, is to help you out. But certainly, I mentioned before, if you did have questions about public access or confidential information, the state's public access counselor would be another good resource to reach out to get an opinion on. So those were the questions that we had previously. So I think got those covered. So any other questions come in, Jenny?
I don't have any others. We'll go ahead and wrap up, and if there are any questions that come in, we can address those. If you are anonymous or your name doesn't show up, make sure to include your name in those questions, and we'll follow up with you later on as well to get those questions answered for you. But thank you all for joining us today. Like I said earlier, we will be sending out an email later this week, most likely on Friday, that will include the PowerPoint, the video, the survey, and also the CE forms. So please, if you do want CE credit, you get 1 hour for this webinar. You would want to fill out that form and then submit that to our office or to your governing body if you're another elected official. But we want to thank you all for joining us today, and hopefully we will see you at a future webinar later this year. Thanks so much.